We're back from recess. Thank you for your patience. We left off, we're on our second round of questioning. We are now, I believe, on Senator Parkinson, and then we'll go Senator Duenas. I'm sorry, just a minute. So we left off at Senator Shelton. So we're now on the Vice Speaker. Vice Speaker, any questions? Senator Brown. Oh. Got confused. No. Okay. I think what we did on the first round was we went up here, and then we go back there. Yeah. Senator Parkinson, you're recognized.
I have no questions at this time, ma'am.
Thank you. Senator Duenas, you're recognized. Senator Blas? All right. Now, Vice Speaker? All right. Can we just...
Okay, colleagues. At this time, I'm going to recognize Speaker Therese Terlai. You may proceed for the panel.
Cesar Masi, Madam Vice Speaker. So I want to clarify again for today that we are now down to that even if the Attorney General has withdrawn as counsel for the 22 agencies that are under investigation, according to the list, he is still going to be able to accordance with 5150, sign the contracts that are over 500,000. Those will be signed and stating that he does not represent any public official, but the contract is approved. And so 5150 requires that contracts will be approved by the Attorney General. Sorry, just a sec. As to form, as to legality, and whether the agency complied with the procurement law.
That is my understanding. Yes, Madam Speaker.
And 5150 also requires that the Attorney General shall, quote, act as legal advisor during all phases of the solicitation or procurement process, unquote. How is that going to happen for the 22 agencies?
We would be, the notice has already been given to the Department of Administration that for a temporary period, pending the court's outcomes, we're going to not act as their attorney in any capacity. So that's the situation, giving the legal advice as opposed to processing the paperwork. If their counsel contacts our counsel, we would always just remind them that you have that letter. What is your question? Because the Attorney General still has the function of providing a legal opinion for the government of Guam, and we will still be conducting that function. But as to the independent legal advice that they may think that we're their lawyer, we've drawn from that. The 5150, I understand, has a procurement counsel, so we anticipate that that person that they can already hire would be contacting our office if they had any questions.
All right, but for another agency, well, the line agencies that they're going to go through GSA and through their procurement council, as is allowed in the statute, or agencies that have their own attorney are going to be being advised by that council as to procurement?
That's correct. Again, some of the qualifiers here, what we're looking at, legality, form, those sorts of things, that would be the type of communication, but with the understanding on the 22 list that we're not serving as their attorney at this point.
All right, and then if the agency, and then you said that if the agencies are allowed to hire counsel, which we might need to do for some of the agencies by a bill, you would, according to your other duty under another provision, it's 5121A, which allows agencies to hire lawyers, but it says that the office of the AG must sign all the lawyers' contracts. Are you going to be able to do that? Without any bill, you will sign the lawyers' contracts?
Correct. Under the airport decision in 2005, if a agency has the authority to hire their own independent attorney at their choice, then we would be required to just look at it for legality and form and not the choice of an attorney. So, and that person would not be an attorney general or an assistant attorney general. They wouldn't be able to prosecute and so forth.
So you're saying if the agency needs to hire a lawyer, depending on whether they're authorized by bill or not, or law to hire a lawyer, but if they did, you're going to sign the contracts.
Correct.
So our contracts over 500,000 will be signed, our lawyers' contracts will be signed. We just might have to allow some agencies to hire that are not currently authorized to hire.
Right, that would be mostly the departments, I think. Those are the situations.
The line agencies.
The line agencies, line departments, and then the, I think Chamorro Land Trust was one of them that we were kind of looking at. They're required to use the AG's office.
What about, so if we did this, how long should we provide for an interim counsel? Under the circumstances, what are we looking at? I was suggesting 90 days in my bill earlier. Are we talking about 6 months, or how long do you estimate before the Supreme Court or Superior Court comes up with a decision?
The Superior Court has time standards, so I presume it'll be within their 90-day windows, but obviously the attorneys have the ability to take it into the Supreme Court, which would normally have the final word on everything, and that could take more than a year. Different options that are available are just putting the caveat there that until the AG's office requests that they intervene to become the counsels pursuant to the statute. You could put a sunset provision in it that every 90 days or, things like that. I think that at least the draft I saw, the most effective one was the AG's office chooses to temporarily withdraw, and the AG's office has the ability to give notice to go back in and provide the services. And on this situation, it's just when the courts finish a analysis.
All right, so the language I saw was to resume representation. And so you think that can be smooth?
I think that's the most effective method. But if the legislature wishes to put a time frame on it, for the lower court, I don't presume anything more than 4 to 6 months.
Okay. And so there's another statute that requires the AG, it requires a procurement counsel for DOA, and then it requires that procurement counsel to represent GSA in civil matters, and it also requires that the AG shall represent GSA. So, and we talked about that earlier, and we said that the remedy for that is just to say if you have withdrawn from representing GSA in those civil matters, then we're going to allow GSA to hire or to be represented by the procurement counsel until you resume representation of GSA.
Correct.
We might need to do a temporary amendment or amend the statute to allow that. What about, can you just walk us through for contracts over 500,000? So the AG is supposed to advise these agencies along the way. But so in the cases of the 22 agencies, you would not be able, you've withdrawn from advising them along the way in these procurements for things over 500,000. So in those cases, they would have to be advised by someone else, either procurement counsel for DOA or their own counsels, right? What if there's like an objection on the procurement? I know if there's a protest, it's going to go to OPA.
Yes.
Will you represent the entities at OPA?
I don't believe we normally do that, but I think well, it's between the bidders normally that challenge it through the OPA process, if there was a litigation involved where the department was involved during our temporary withdrawal, they would be having to get their own counsel for that, to provide them that representation. But also the procurement counsel is available for that. It's in the statute already for DOA.
So the AG's office does not get involved in, like, for example, while there's a procurement, they're going through the procurement process, and one of the bidders says, I object, or
Right.
that's wrong. They ask the agency to reconsider that. The AG does not advise at that point.
And I'll stand corrected on that. Mr. Botha can intervene. My understanding is that a lot of what occurs in the OPA is between the department and the bidder, the one that's challenging the bid. I don't recall us getting involved in that leg.
Right. Well, the statute says that you will be, so let's just assume that you are able to be. But now the agencies will not have your representation,
Right.
so they're going to be represented by someone else.
That's correct. That
okay,
would be
all the way up to, you're saying, the signing of the contract, which you are willing to do. But
Yes.
everything up before that, including OPA protests or protests at the agencies, no advice. That's correct?
Graham, right now, I don't believe that we're actually getting involved in this. Graham?
Senator, to the extent that, I mean, normally what would happen is, let's say there was a protest during the process, then the agency would respond and say, I either agree, and that they'll send out an amendment to change something, or they would send out a denial and say, I deny your protest. And of course, then it's up to the vendor to determine whether they want to take it up to the OPA or not. And a lot of times they won't, you know.
But in order to do that, did they receive the benefit of the Attorney General's counsel?
Well, they would normally, except for the circumstance now for the 22 that would not provide the advice for. But the ones that aren't on that list, we would certainly provide the advice as needed for them.
But currently, I don't think that we have any before the public auditor.
We don't.
That is my understanding.
At this point, we do not have any pending before the public auditor.
So practically speaking, the past year or so, we have not gone before the public auditor on behalf of any of the departments. What I've seen is that they're actually using the bidders themselves, the one that won against the one that is objecting, is going before the
How
OPA.
many contracts do you have potential, I guess, for your review for signature under the $500,000 provision?
I think the stats that we had on that is there's about approximately 150 contracts that were pending for review.
And
For
is
the
that
entire government of Guam.
Yeah, for the entire government.
and you're saying that, so yesterday you said those would be signed, what was the time period, and all of them?
Within 30 days, they get that review. Some of them are sent back. Some of them are ready for signature. Of the 22 that we're going to have to scrutinize, we're going to put the disclosure and then approve and sign it if it's ready for that.
Say that again?
We have 150 for total
Will you be
government.
louder? Sorry.
We have about 150 for total government of Guam. There's now 22 that have been flagged with the letter and so forth. So for those, they'll be reviewed ordinarily, be sent back if there's a problem with the disclosure, and then when it comes back and it's ready, we'll sign off on it, but we're going to stamp we're not acting as their attorney when we're reviewing it. That's the procedure that we're using right now.
But what do you mean if there's a problem with the disclosure?
Not the problem with disclosure, but just once it's reviewed, we'll sign off on it, but we're going to put a note on it that we're not serving as their attorney.
Okay, so there's no delay for any of the contracts to be signed, you're saying?
Not
You're
at all.
going to, within 30 days, even the 150 that you have right now, and any others that are sent in, be able to review and either approve with that stamp for the 22 agencies, or approve regularly, or not approve, you reject it, and you send it back.
That is correct.
Mr. Botha, are you trying to?
Yes, Senator, just to clarify, obviously if the agency doesn't submit all the documents they need to, sometimes they're just not very speedy in responding to the Civil Division. So if we ask them to submit additional documents and determinations, obviously we're stuck until they actually forward those to us. So that's some of the reasons why there could be a delay, but all other things considered, we do our best to get them out the door.
The other part of the procurement process where the AG was involved was the one where lifting stays, right? Sometimes the agencies say these are very critical matters, and even if there's a protest, the automatic stay should be lifted. And they've asked the AG to sign off on those as well. GPA complains that the AG is not responsive or was not responsive. We've heard the explanation from the AG why they were not in that particular case. However, what is your criteria for all other agencies? How do you determine whether you're going to agree to lift the stays or not? You've said you're going to continue to do that there's no impediment to that right now, even for the 22 agencies.
Correct.
You will be able to do that or not do that based on what?
You see, just the idea that the legislature requires the Attorney General to decide to lift a stay or not to lift a stay, I think embodies that we're not acting as the attorneys for these departments and agencies. Because obviously the attorney, if they did just represent them, would just lift it because that's what the department head wants. So practically speaking, I do not know of anything that's been asked of us to lift a stay in this adjudicative type of hat that we wear. And on the GPA matter, the decision was made not to agree to lift the stay. That's the only one that I'm aware of that's come through our office. Graham, if you can confirm.
That's correct, and actually under 5 GCA 5425G, generally it would be more appropriate for the procurement protest process to take its course. I mean, this would be extraordinary remedy that, Chief Procurement Officer, and all the rest would ask that basically it's so important that, the contract should be awarded without delay. Well, that, of course, would give no due process to whoever's protesting, and certainly there may be a valid protest. So, I mean, it would be a very extraordinary remedy that the AG would ever do that, and to my knowledge, it hasn't been done in quite some time, I mean, if ever.
All right, thank you. So I'm proposing, and I got some of this language from the Governor's Council's draft. I pulled out a couple of the provisions, and I'm want to confirm whether you are recommending that we do need to have a bill to address at least a couple items. So even if you're able to sign off on all the other contracts that I just went through with you, that on, for example, Section 5118, Procurement Council, and the one that says the Procurement Council assists the Chief Procurement Officers, and then the Office of the Attorney General shall represent GSA, and then I'm suggesting to add in the language that was proposed, unless the Office of the Attorney General withdraws from such representation or fails to perform such representation for a period of 5 continuous days, then the Procurement Council shall represent the General Services Agency in such civil matters until the Office of the Attorney General resumes such representation.
Madam Speaker, may I ask that notice be given to the AG's office as opposed to something falling through the cracks? So it's the proposal as I see it on this draft, the draft that I have in front of me, unless the Office of the Attorney General withdraws from such representation or fails to perform such representation for a period of 5 continuous days, and notice is given to the AG's office. Okay.
And then again, on 5150, adding in a similar paragraph to the end. So this is the section of the law that requires you to review contracts over $500,000 and to represent agencies in the procurement process, adding in a paragraph on the bottom that says, notwithstanding the foregoing, if the Office of AG withdraws from representing or declines to provide legal services to the government body, while the government body is conducting any solicitation or procurement estimated to result in an award of $500,000 or more, or withdraws from acting as the legal advisor for the governmental body conducting such solicitation 7 days after receiving notice of the solicitation or procurement from the government body, then the governmental body may conduct the solicitation or procurement without the assistance of the Attorney General. So that means they will conduct it without you, either with or with their other counsel or with the procurement council, until it gets up to signing the actual contract. That remains intact. You will sign the contracts, 500,000 or more.
That's correct. Madam Speaker, if I may, the provision, the one we were just speaking of, unless the AG's office withdraws, which is a notice to the department from such representation, or fails to perform such representation for a period of 5 continuous days, I'm kind of concerned about that. It takes us about 30 days to go through the contract, so I would hate to see the contract or the department say that they're going to move forward just because they haven't heard from us in 5 days. I think the notice itself, to just trust the AG's office to give them notice that we need to withdraw, would be more respectful of the idea that we're trying to protect everybody's rights in these. Same thing with the second section, the 5150, that allow the AG's office to give them notice like we did through that letter, and then they can proceed until such time as we request to re-engage our services with them.
So what you're saying is that if they haven't heard from you, you have not failed to represent them, you have just not got to it yet, and you want them to continue to consult you.
Right, because right now the...
Unless you've given them a formal withdrawal from representation.
Would you please consider incorporating that, so like we did here, the February 28th letter, that we're temporarily withdrawing, and then allow us the ability to re-engage the services?
All right. Okay, and, sorry, wait a minute. What about, so the current, do we need a provision for the entities that are going to be allowed to hire counsel that are currently not allowed?
In this procurement, there was a version that I saw that did allow them to, in this situation, they should be allowed to retain counsel.
All right. Okay, and then again, you've promised to sign off on those contracts.
That is correct.
All right. Thank you, Madam Chair. Thank you to the Attorney General and the panel. I think I'm the last one, so
Thank you, Madam
Masi.
Speaker.
Yeah.
Thank you, Madam Speaker. This ends the second full round. So at this time, we will dismiss the panel. Thank you very much. We'll be in a moment's recess.
Thank you.
Imina Chantashetina Legislature in Guam is back from recess at this time. I will recognize Speaker Therese Terlahi on the motion to rise.
Madam Chair, I move to rise and go to motions, return to motions.
On the motion to only rise, Madam Speaker, can you please correct that? On the motion to rise to get out of the committee.
Yeah, there is no recommendation by the committee. There's no action by the committee, so there's no recommendation that the body is going to accept. So I'm moving to rise and to return to the motions on our agenda. On my motion.
Madam Speaker, I'm going to ask you to fabricate that bill because it's a motion to rise and a motion, and then the second request can be done by another motion. So unless somebody objects to the chair, I rule that. So make the motion to rise out of committee, please. On the motion to rise out of committee, are there any objections? Seeing or hearing none, motion carries. To rise out of committee is... There was a motion made by you to... I will acknowledge Senator Will Parkinson on a motion to rise and get out of committee.
At this time, ma'am, I'd like to make a motion to rise out of the committee of the whole.
On that motion, are there any objections?
Objection.
There is an objection. All those...
You just
On the
said, Madam
motion
Chair, okay,
to
Madam
rise-
Chair, you just said we could not make a bifurcated motion, and you did not
On-
even count a vote on it. So I
you,
object to
Madam
any
Speaker.
other bifurcated motion. In fact, I
Thank you,
object to
Madam
this whole
Speaker.
process.
On the motion to rise out of committee, are there any objections? Seeing
No
and hearing
motion,
none-
there is no such motion.
Seeing or hearing none, motion carries. We are in recess.
There was no motion, Madam
We are
Speaker,
in
for
recess.
that.
With all due respect, if anybody wishes to overturn the
Oh, order, Madam Speaker, Madam Chair. If we can get legal advice right now, because it's obvious you don't have any.
We're back from recess. We've risen from the committee of the whole. Majority Leader, you are recognized.
Sedua Masi, Madam Speaker. I move to add Bill 254-37 COR as substituted on the floor to the agenda. Oh, I'm sorry, excuse me. I move to go back to motions for the purpose of adding Bill 254-37 COR as substituted on the floor to the agenda.
I'm going to have to bifurcate that, and there's a motion to go to motions, back to motions. There's been an objection. All in favor of going back to motions, please raise your hand. Motion fails. Majority Leader, you're recognized.
That's it, Madam Speaker. I think we're in the voting file.
Senator Burnett, you're recognized.
Thank you, Madam Speaker. I'd like to make a motion notwithstanding the rules to add Bill number 255-37 COR as substituted on the floor. The second reading file, and the purpose is so that we can, as you're aware, the Attorney General in his discussion had talked about withdrawing representation for agencies, and this bill would allow the agencies to hire their own counsel in the event the AG withdrew representation, ma'am. So I'd ask the support of my colleagues in placing this in.
There's a motion notwithstanding the rules to place Bill 255 as substituted onto the session agenda. There's been an objection. All in favor, please raise your hand. Motion fails. Folders have been passed out. We're now on the third reading, or the consideration of the daily file, beginning with the third reading. Bill number 206-37 LS. Clerks, please read the title.
Madam Speaker, I move to excuse members not present for this vote.
There's a motion to excuse members from voting who are not present. Is there any objection to that motion? Seeing no objection, motion carries. Clerks, please read the title on Bill number 206-37 LS.
Bill number 206-37 LS, as amended by the Committee on Environment, Revenue and Taxation, Labor Procurement and Statistics, Research and Planning, and further amended on the floor. Introduced by William A. Parkinson. An act to add a new section 8113.15 to Article 1 of Chapter 8, Title 12, Guam Code Annotated, relative to providing temporary emergency power capacity.
Roll call.
Senator Barnett. Senator Barnett, nay. Senator Blas. Senator Blas, aye. Senator Brown. Senator Brown, nay. Senator Dueñas. Senator Dueñas, aye. Senator Fisher. Senator Fisher, aye. Senator Lujan. Senator Lujan, excused. Vice Speaker Muñoz-Barnes. Vice Speaker Muñoz-Barnes, aye. Senator Parkinson. Senator Parkinson, aye. Senator Perez. Senator Perez, nay. Senator Kanata. Senator Kanata, aye. Senator San Augustine. Senator San Augustine, aye. Senator Siniclis. Senator Siniclis, aye. Senator Shelton. Senator Shelton, aye. Senator Titagui. Senator Titagui, nay. Speaker Terlahi. Speaker Terlahi, aye.
Bill number 206-37 LS received 10 ayes and 4 nays and 1 excused. Bill number 206-37 LS is duly passed by this body. We're now on brief extension of remarks. Is there anyone who would like to be recognized? Vice Speaker. Majority Leader, Senator Shelton, you are recognized.
Thank you very much, Madam Speaker. I'd like to take the time to wish everyone a happy Mes Chamorro, as well as a happy Women's Month. And tomorrow we will celebrate International Women's Day here in the legislature. And we invite all women to join us at noon tomorrow, especially our colleagues here, for a resolution presentation in honor of Women's History Month and International Women's Day. Sidus Masi.
Sidus Masi. Senator Titagui, you are recognized.
Sidus Masi, Madam Speaker, and to my colleagues, I too would like to wish everyone a happy Mes Chamorro and Women's Day, but as well to wish Happy Charter Day to the University of Guam. Unfortunately, some of us had to be here for emergency session and couldn't make it. So I just wanted to extend congratulations to the University of Guam and let them know that we would have been there, but this is very important to address. Madam Speaker, I think it was clear during deliberations on 206 and especially afterwards when we spoke on what I would seem no real reason why we should have had an emergency procurement for GPA, that it should be done with a non-emergency procurement, and we would have found that there would have been other options instead of this very expensive $25 million for 2 years for generators. We already knew that there was a protest. And sometimes you think that protests are just frivolous and they're just meant to stop it because they didn't get awarded. Well, that goes the same for agencies and departments who find ways to overcome not getting what they want. Because somebody out there is pushing for them. And I mentioned earlier, Madam Speaker, that I have a great concern when agencies go out and use public funds to promote individuals who want to bid. And they did that at GPA. They use public funds for that. And that's a big no-no for procurement. I'm hoping, Madam Speaker, even though this bill had passed, I'm hoping that certain things doesn't happen. One, that they start load shedding anyways. Two, that our rates to our power bill is going to go up because GPA failed to provide the best option for the people of Guam on creating generated power. There were other options, less expensive. So if anybody asks me why I voted no, those are the reasons. We're opening Pandora's box every time an agency doesn't get their way because they fail to do their job and responsibility. And if there's any place where their employees receive 6 figures and have gazillion of engineers can't do their job, then there's a huge problem. And that this is what the body should be addressing. I just hope to goodness those two things don't happen. But I'm not confident that it won't. I'm really not. I'm also confident that they'll probably come to us. I'm also confident on one thing, that they'll probably come to us again when they don't get their way and start using the customer bank that they have to promote their way or the highway. This is something we all need to think about. We don't want load shedding, of course not. None of us here do. But the way that it's going about it, it's absolutely wrong. We put these rules and regulations and procurement in place for a reason. Not to disregard it or notwithstanding. And it's very shameful. Some of the comments that were made to the Attorney General in this body. We all know they had their own special agenda on that. But this Attorney General and his office has done everything with the little amount of attorneys that they have. There's a shortage of attorneys on this office, and every single one of them stays after work to finish their job because they're shorthanded. And every time you see a conviction out there, it's because they're doing their job. And instead, we have certain people in this body trying to sabotage them. That's shameful. Very shameful. Please know, the people of Guam, that we're doing what we can. We're just asking that the agencies do what they can do as well. And quit being so lunga. Thank you, Madam Speaker.
Thank you, Senator Parkinson. Under extension of remarks.
Thank you, Madam Speaker. I just want to be brief. I want to wish 3 special beings in my life a happy birthday this month. Yesterday was my wife Camille's birthday. Happy birthday, my love. Earlier this week was my mother's birthday. Happy birthday, Mom. And earlier this month was my dog Rocco's birthday. He's now 11 years old. He's a wonderful German Shepherd and Akita mix. May we have many more happy years together with those people in my life. And so I just wanted to express my happiness and joy, and have a good day, everyone. Thank you for your support tonight.
Thank you, Senator. Is there anyone else who'd like to be recognized on extension of remarks? If not, then Legislative Secretary.
On brief extension of remarks, Speaker Terlahi, you are recognized.
Thank you very much. And I want to thank my colleagues for the cooperation that we had during this emergency session. And I really just want to wrap up this emergency session by pretty much summarizing what, in my view, occurred here. So we came in for two purposes. One was for Bill 209 that became an emergency because although it was reported out of committee in the last session, no motions were made to put that on the floor. So then it just lingered and became an emergency. And yes, I agreed that we should consider it, despite no proper motions being made earlier. On the eve of our consideration of that bill, we received communication from a potential bidder, I guess, and I'm just hoping that the bill that we pass, the form that we pass, is going to be reviewed by the Attorney General with all these things in light, and that he will be able to approve or not approve based on legality, a determination of the legality and the adherence to the procurement law, despite the things that we waived, But I'd also like to talk about the second topic that we were called in for emergency session, and that was because the Attorney General of Guam declared last week, and I found this out from a phone call from the governor one morning, that she had received communication the night before that the Attorney General had withdrawn from representing 19 agencies at that point, because those were the agencies under investigation based on OPA findings or other findings. So he withdrew from council, withdrew from representing these agencies, which in my discussions with the governor, it seemed like left these agencies without anyone to sign off on contracts over $500,000, anyone to advise them in the procurement of these contracts, especially those over $500,000, anyone to advise these agencies, for example, the Chamorro Land Trust, in these complex leases that they are trying to enter into, and that's the situation we were facing. And yet you heard it all of you heard it. In the governor's message, she's asking for us to participate and cooperate and work together, collaborate, to address that and other things that this government faces. Well, all I know is what I did, and I worked all weekend long trying to come up with a solution on this, trying to figure out what is the extent of the problem and what are the limits of what we can do. Because we are very much tied up by the Organic Act of Guam. And we've had a barrage of all kinds of things happen down here, including we've had our lobby full of GPA lobbying over and over. We've had our lobby full of lawyers trying to tell us, what are we doing getting involved in the middle of this crisis that we are facing with the Attorney General, that it's a manufactured crisis. Whatever it is, you don't like him, I get that. But we have an Attorney General withdrawn from council, withdrawing as counsel to agencies, and these agencies need our help. And I'm very disappointed in some of my colleagues in not wanting to give that help to these agencies. Whether you like the AG or you don't, you like the governor or you don't we want our agencies to be able to function? And I think we can do that with a very narrow bill based on what we heard from the Attorney General in his testimony today and yesterday. We can do that. We can make it narrow. We don't have to give the governor any more superpowers. We just have to give a narrow bill, which I believe I have proposed to this body. And whether I proposed it or anyone proposed it, I just believe we should work on a bill, and we shouldn't be so tired that we can't deal with that. Because yes, it's ideal to have a public hearing. I'm all for it. But not while we've got agencies who cannot move, who may not be able to move. And we're just going to have them languish while we make the notice for the public hearing, while we listen to days of testimony. We have to notice a session, come back in again, do it all over again, when we could have helped them right now if we would just put our heads to working. I don't know. But I just want to talk to the governor, and like, if you want collaboration, then you got to talk to a lot more people than just me down here, because I have been collaborating, but I am working hard without much cooperation. And the people of Guam, I'm sorry that we could not come through for you and these agencies who are delivering critical services, such as the shelter, such as contracts, such as GURA, such as all these agencies that just need us to focus and do our work. But I did my best. I want to thank those who supported putting my bill on the agenda, and which I thought would have been a good solution, a very narrow one without giving extra, using the emergency as some vehicle for extraordinary powers. I don't think that's called for either. So I just want to thank you, all of you, as we conclude this session. Sizus Masi.
Sizus Masi, Madam Speaker. Senator Barnett, extension of remarks.
Thank you, Sizus Masi. As you guys are well aware by now, I'm sure you've learned that the governor has vetoed Bill 185-37, and I've been asked by many people for my response relative to the governor's veto of the bill, and I will now give it. So during the governor's State of the Island address here in this hallowed hall, she had remarked that Bill 185-37 barely passed. And the governor, as a former senator, should know very well that when it comes to legislation, there's no such thing as barely pass. There's only pass and fail. And Bill 185-37 garnered the support of a majority of my colleagues here in the 37 Guam Legislature. Something that the governor's effort to build at Eagles Field and the governor's effort to build at Edagaga could not do. The governor, in her State of the Island address, also remarked that our ideas have to be greater than just opposing her own ideas. Now, the problem I have with that statement is that it runs on the assumption that the governor's ideas are somehow better than everyone else's. And I think that just because an idea opposes hers doesn't mean it's not a good idea. The governor also remarked in her speech that the decision to build at Edagaga was not something that she did because it was what she wanted to do. She remarked further that she had conducted outreach, that she had done research. Well, we never saw that research. We met with the governor at Adelup, the Democratic colleagues. I met with the governor in good faith because I wanted to hear, just like Eagles Field, just how good this deal was, so that I could make a determination with the facts before me about which one of these efforts I would support. The governor told the colleagues and I that the federal support that she's seeking for Edagaga would follow wherever we decided to build the new hospital at. So that means if we built at Edagaga or we built at Ipao Point, the federal government is going to support these efforts. I was very disappointed and hurt even by the governor's veto message. The governor's veto message was about 2 pages long, and I scoured long and hard. I even put on my reading glasses because I wanted to see if there were any facts in that 2-page letter. Unfortunately, there were not. It was one long personal attack, which is unfortunate because since day one, since the first day we started discussing the effort to build a new hospital for the people of Guam, instead of engaging in real, honest debate and discussion, Lou and Josh have opted, since day one, to engage in name-calling and personal attacks, obstructionists, anti-American. In the veto message, they said I was a clown who caters to special interests. That is not only an insult to me and my family, that is an insult to the thousands of people of Guam who support what I am doing in this House. We have an obligation to make the best decision for our people. And when I make a decision, I just don't make it because someone told me to. I make it because I look at the facts before us. And the facts before us in the matrix study clearly show that EPAL Point is the fastest way we can build a new hospital. It's the most feasible. It's the most fiscally responsible. And it is the site that was supported by a majority of senators in the 37th Guam Legislature. The people have spoken, but unfortunately, the governor and the lieutenant governor didn't like what we said. So many have asked me what I intend to do next. It's my intention to seek support for an override. Si Dios Masi.
Si Dios Masi, Senator. Majority Leader. Is there anyone else who'd like to be recognized under extension of remarks? If not, the Majority Leader, you are recognized.
Seduus Masi, Madam Speaker. I move to adjourn today's session, subject to the call of the Speaker.
The motion to adjourn, is there any objection? If not, we adjourn, subject to call of the Speaker.